Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the United States Supreme Court, best-selling author, and most importantly, proud American gun owner. If you haven't subscribed to the Four Boxes Diner, please do so and show your love for the Second Amendment's right to keep and bear arms. Okay, folks, I have terrible news. Shocking and terrible news, mission critical, especially for people out there in the state of California. Mission critical information. I can't believe that I just heard about this now because this seems to have been in the works for some time and I haven't seen anything about it anywhere. Huge, terrible news in my opinion. The state of California is passing an amendment to their Code of Civil Procedure. According to my information, the name of the change is involving Section 1021.11. 1021.11. The name of the statute with Governor Gavin Newsom is either signing or about to sign is AB, and you people in California know this stuff. It's AB 1327. Apparently is the California designation for the law. So my commentary today is about what this law is. I'm actually shocked as an attorney to see this law because I've never seen anything like this in my life, and I've seen a lot. So what happens is this, that the state of California is passing this law, apparently, that literally says that anybody that brings a lawsuit challenging a gun or firearm regulation or law on, among other things, Second Amendment grounds, presumably, or any grounds for that matter, including but not limited to Second Amendment grounds, if you do not win your entire lawsuit in all respects, if you lose any aspect of the lawsuit in any respect whatsoever, you, the plaintiff, meaning the person that sued, any organization that sued along with the plaintiff, also as a plaintiff, like organizational standing or something, I presume, and the lawyers and the law firm that brought the lawsuit against the state of California must reimburse the state of California for all of their attorney's fees and their costs, presumably for the outside law firm they will use, who will be doing this pro bono until they presumably win, at which point they'll give you $1 million legal bill that you will have to pay as the plaintiff. The gun organization, if they're a plaintiff, will have to pay, and the lawyers and the law firm that are representing these people will have to pay under the statute. Specifically, I'll read this to you right here. It says, "There, notwithstanding any other law, any person, including an entity, attorney, or law firm who seeks declaratory or injunctive relief," that means to stop you. That just means to stop, declare something unconstitutional, "to prevent California and its local governments, the state or local governments, cities and their officials, from enforcing any law that regulates or restricts firearms in any state or federal court, or that represents any litigant, that's the plaintiff who sues, seeking that relief in any state or federal court, is jointly and severally liable to pay the attorney's fees and the costs of the prevailing party." Now, the definition of prevailing party is only the state of California or any of their subdivisions or any of the other people that represent or work with the state of California. It can never be you, the plaintiff. It can never be the gun owners of the plaintiff. The only possible prevailing parties under the statute is California and the cities and the localities that are being sued, presumably, for violation of, among other things, their Second Amendment right to keep and bear arms. Now, this is absolutely shocking, and this will have a tremendous chilling effect and almost prevent the challenge of these gun laws in California under the Second Amendment that's been going on for decades. This is why I say this. Stand back for a second. These lawsuits involving the Second Amendment are not profitable financially. What I mean by this is not like suing Elon Musk for $1 billion. You're not suing Facebook for money for breach of... You're not suing people for a lot of money, right? You're literally just suing the state of California or their cities or their political subdivisions saying, look, you've passed a regulation, you passed a law, it violates the Second Amendment's right to keep and bear arms, or it otherwise violates my right to protect myself, my right to self-defense, whatever the argument is that's being made. You bring this lawsuit. Happens all the time. It's happened literally for 100 years in the United States. People have been bringing these civil rights lawsuits vindicating all sorts of constitutional violations, all the way from African Americans in the South to, gays seeking gay marriage, to people that want the right to an abortion, have been suing laws, challenging, saying they have a right to an abortion. These things have been going on for forever in the United States history, basically. Now, what California has done is they basically are saying, yes, that's nice, but if you try to vindicate Second Amendment rights, and you don't win every aspect of your case, and this is the kicker, even if you win the lawsuit, even if you have the law struck down as unconstitutional, if you have asserted 5 different theories, let's say, Second Amendment, Dormant Commerce Clause, First Amendment, whatever it is, and you lose on any one of those, even though you ultimately win the case, according to the statute, as I read it, you have to pay California their attorney's fees, which I assure you, at a minimum, on a good day, will be hundreds of thousands of dollars. And realistically, if we're talking about a multi-year litigation that goes up and down the appellate courts, you're looking at millions of dollars in attorney's fees. Trust me, I've seen big legal bills. They're really, really huge at this level of constitutional litigation. So the bills that will be presented to the gun rights plaintiffs will be astronomical, is my best guess. That's what at least I'm guessing, and I'm pretty confident I would be right on this guess, by the way. Let me tell you why I think this law is probably unconstitutional, but someone's going to have to litigate it and get a court to agree with me. My saying it doesn't make it true. First, under the First Amendment of the Constitution, it says that you and I have a right, quote, to petition the government for a redress of grievances. To petition the government for a redress of grievances. Well, I can't think, that means you have a First Amendment right to bring a lawsuit to vindicate your constitutional civil rights under the Second Amendment, as best I can tell. That's what the First Amendment says. So I think there's a First Amendment attack on this statute. The second way to look at this is I would view this as a form of a poll tax. So basically they're saying that if you're going to bring this lawsuit, you're going to either have to buy insurance or do something to protect against having to pay the fees at the back end, or you're going to run losing all this money at the end and going bankrupt. Because remember, the plaintiffs aren't going to be suing for any real money. They're just suing to enjoin a statute. They're not suing for billions of dollars or anything like that. They're just suing to enjoin or declare a statute unconstitutional. There's no real money here. So no one is going to risk going into financial bankruptcy or ruin because they were willing to volunteer to bring a lawsuit. So I don't think that's going to happen. So basically, this is a form of a poll tax as I see it. We know that poll taxes on voting are unconstitutional. We know that there's actually been cases out there where a $1.50 poll tax has been declared unconstitutional between you and your right to vote. So this is certainly, the risk of financial ruin is certainly going to be more than $1.50 here under the way California wrote this terrible statute as I see it. So I think you could argue that it's a form of a poll tax. I think the third thing is that federal law, remember, under the U.S. Constitution, you have something called the Supremacy Clause. What is the Supremacy Clause? The Supremacy Clause says that where a federal law and a state law conflict, the federal law governs because of the Supremacy Clause. It says federal law is supreme over state and local laws. Now, there's a federal law dealing with attorney's fees in civil rights cases, including cases brought to vindicate Second Amendment rights or to say that a state or government is violating the Second Amendment. That is a federal statute called 42 U.S.C. 1983 and a related statute, 42 U.S.C. 1988. These are famous civil rights statutes. This is how every First Amendment lawsuit is brought, every Second Amendment lawsuit is brought, any constitutional violations lawsuit involving a constitutional violation. These are how you get to federal court and allows you to sue in federal court. So, I think the fact that you have these federal laws that say that if someone violates your, among other things, Second Amendment rights, you can go to federal court and get vindicated under these federal statutes, to me is strong evidence that the state of California trying to end run around these could arguably be violating those federal civil rights statutes because they're basically now restricting who can use those federal civil rights statutes because they're saying if you can use those federal civil rights statutes for all sorts of claims about gay rights, about abortion rights, about First Amendment, about religion, about free speech, whatever. You can do all that you want in California, but if you touch on guns, the firearms, the Second Amendment, then you're going to be risking financial ruin and bankruptcy. And I think there's a good chance a federal judge will be like, this law is not allowed, given the fact that the federal courts have already, and Congress has already passed a law governing these attorney fee provisions, and yours essentially conflicts with the federal law, and therefore it's unenforceable. But again, some court's going to have to actually say this. So bottom line is this. I just found out about this statute. I wanted to bring it to your attention immediately. I usually don't deal with legislation. This is not kind of what I do. But when I found out about this and I saw what this would mean, and what this will mean is that plaintiffs will not voluntarily become the plaintiff in a lawsuit challenging gun laws on Second Amendment grounds because they don't want to go bankrupt. The law firms and lawyers, I'm guessing, will not want to, because they're going to be jointly and severally liable for the cost and the fees of California. They're not going to be willing to risk financial ruin and pay all this money when they're really, I mean, who knows how much they're getting paid. But I'm guessing, again, these Second Amendment cases, as a financial matter, I'm guessing are not that lucrative relative to like commercial litigations. This is not fighting over billionaires. You're not fighting about who owns Twitter. Those are huge cases. You can make a ton of money on those kinds of commercial cases. But, trying to vindicate Second Amendment rights involving gun laws in California or any of these places, again, the reality is you can make a living, but you're not going to get rich and fly private planes as a general matter if this is what you're doing, is the sense I have, given the nature of these civil rights constitutional type claims. Okay, I hope you learned something here at the Four Boxes Diner. And if you haven't subscribed, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.